Hey, Pat Welsh here. You know what that means? Taco Tuesday. Take action, crush obstacles. Welcome back to the Warrior Servant Leader podcast. Glad you're here for our next episode, 16, titled, Can You Survive a Courtroom Battle? So before we get started, quick shout out to our friends and supporters at Law Enforcement Today, Kyle Reyes and all his folks at Police Tribune and Blue Lives Matter. Great supporters, long time, and I'm honored that they allow me to be a part of their family. So, who hates going to court? I can see you. I can see you. You're raising your hand. You're nodding your head. Why? Why do you hate going to court? I loved going to court when I was a police officer and as an attorney, as a prosecutor. Most folks in law enforcement hate going to court for one or more reasons. One of the big ones is courtroom testimony is a form of public speaking. And there's research out there that, one of the greatest, if not the greatest fear that people have is public speaking. Not dying, but public speaking. They're just terrified of that. And testifying in court is public speaking, and in a very dramatic way, because you are the center of attention and subject to cross-examination. And that's the second reason why most cops hate going to court. They do not like defense attorneys. Most of them seem to be the south end of a northbound horse. They're rude. They are just jerks. Not all of them, but a good many of them are. And probably number 3 on the list of why you hate going to court is if you work, the evenings or the night shift, 8 o'clock in the morning, you're supposed to be home in bed, but instead you're sitting in a hallway outside the courtroom, waiting and waiting and waiting for hours sometimes to go in and testify. And it just throws you off physically, emotionally. You're dead tired, and you're thinking about all the things that you got to get done once you leave court. And it just screws up your day, especially if it's your day off. Probably the last thing on the list is a lot of cops don't like testifying because they're afraid they're going to blow it on the stand. They're going to say something wrong. They're going to screw up. And that's that fear factor that they would just assume, forget it, and walk away. I mean, some of the best words you ever heard coming out of the courtroom is when the prosecutor comes out, DA comes out and says, hey, you can go home. Your defendant's pleading guilty. But so often we have to get on the stand. We have to testify. And it feels like a battle. It feels like a verbal battle with a defense attorney. And you feel like a fish out of water because you're not in command. One of the principles of communication is that the person asking questions controls the conversation. And we're used to asking the questions and controlling the conversation when we're on calls for service. And we get in the courtroom, we don't know what the question's going to be, especially on cross-examination. Hopefully you know what it's going to be if it's a DA asking you because you had a meeting, a pretrial meeting, and went over things. But how many times have you gone to trial, not on the big cases, on those little misdemeanor cases, those traffic offense cases, and you go in and the city prosecutor goes, hey, I haven't had a chance to look at this file. Can you tell me what happened? And that just takes the wind out of your sails of why am I here? I'm prepared, but you're not. And it disappoints us, especially if you're off duty, that, why am I wasting my time if you're not even prepared to go forward? So all those things are going on in our heads, and it happens all the time. I mean, I remember one year from January 1st through February 15th, that's 6 weeks. I had court every single day. And I was working midnights, 11 p to 7 a. And I had court every day, Monday through Friday, for 6 weeks. And I was exhausted by the end of that time. And so we do that, and you do it for years. It builds up your frustration. So, how can you survive a courtroom battle? You know, we've all been given street survival, but we haven't been given court survival training. How do you survive being attacked in cross-examination? Or how do you survive a prosecutor that is not prepared? And the burden is on you to make this case stick. So that's what we're going to talk about a little bit today. Courtroom survival. And I'm talking from 40 plus years. Gosh, now it's coming up on 43 years that I've been in that arena, either as a prosecutor or as a cop. I was an expert witness for a few years on law enforcement kind of stuff. And I've testified in everything from jaywalking to aggravated murder. I've even testified in different states. And one thing I have learned is that testifying in court is a ton of fun. That's right. I love going to court. I love being in the courtroom as the prosecutor. I love being in the courtroom as the witness cop on the stand. And part of that was because of my mindset. When we go to court, so often we think this isn't our playing field. This is not my home. You know, this is the lawyers and the judges and the court personnel and a jury. You know, I'm on their turf. That's not true. The only reason you're having a trial is because you did, or your other cops that you were working with did a great job, that charges were filed. You own the courtroom because you own the case. And we don't carry that mindset with us when we go to court. We feel like we're on somebody else's home field, and we're not. We're in charge. Believe it or not, you're the only person that knows the whole story from start to finish. Because the DA knows bits and pieces, and they put together a trial strategy. The defense attorney thinks they know everything, but they don't. And you do. So develop that bulletproof mind, if you will, like Colonel Grossman talks about in the Street Survival. Have that bulletproof mindset going into the courtroom. So why do you go to court? There's only 3 reasons why you go to court. Tell a vivid story of the event, to create a picture with words that the judge and the jury can follow. So you're creating a story. Secondly, you're there to convince the parties of the defendant's guilt. The parties include the judge, the jury if there is one. Now get this, it's also to convince the defendant and his or her attorney that they're guilty. And every time you get to testify, not just in a trial, but in a motion to suppress, that's a courtroom battle. And in a motion to suppress, if you tell that vivid story and you convince the judge of the strength of your case, then you're also convincing the defense attorney and his client, maybe we ought to work out a plea deal here, or plead as charged and not go to a jury trial. So every time you testify, grand jury, preliminary hearing, suppression hearings, the actual trial, You're there to tell a vivid story of what happened, convince the parties, the decision makers, of the defendant's guilt, and thirdly, successfully conclude your case. Get a guilty verdict for the crime charged. That's why you're there. You're not there to get justice. There is no such thing as justice. There are guilty people that are walking free, and that's not just. There are innocent people that have been sent to prison for a variety of reasons, all of which were wrong, and that's not just. So justice is a nice catchphrase, justice is blind, all that kind of stuff. No, it's not. So your job is to go in there and tell the truth of what happened so the people that are in the position to make a decision can make the right decision. So a couple of principles that you need to grasp to successfully do these three things. One, here's how the human mind works. You hear in stereo, you remember in video, and you think in questions. That's how the human mind works. And you ask yourself 1,000 questions a day. And people process information in a learning environment. And for a judge and a jury, hearing a case for the first time, hearing the facts, that's a learning environment. And they're hearing it and they're picturing what happened, and then they're processing that information so that when they go in to decide and deliberate, they can recall the testimony and then process that information into a verdict. So that's one principle. Another principle of courtroom survival is, and I was a bailiff, so this is where I learned this. When I was a bailiff in law school, I worked for a judge that did felony, criminal, and civil cases. So I got to interact with jurors. And after trials were over, the judge, because he knew I was in law school, that I wanted to be a DA, he recommended to me, hey, after the decision has been reached and the jury's been dismissed in open court, and they're going to go back to the jury room and you're going to take them there, feel free to ask them questions. And so I started doing that. And here was the one fact that came out in almost every single case, whether it was civil or criminal. Every juror believed that they were there to hear this case only because somebody was lying about what happened. And their job is to figure out who is lying and what is the truth. And I found that extremely important to me then throughout my career is their mindset coming in is somebody's lying. And I'm going to get to that. I mean, when I tell you some of the solutions to surviving a courtroom battle. Another principle you need to understand is there's two types of language that we speak, at least in the Western culture. And I'm sure this is universal, but there's only two types of language that we speak. One is intellect, your mind, where you're analyzing and rationalizing, and the other language we speak is emotional. And you know both of those when you're on calls for service. You go to a family trouble and you get there, and emotions are running high. So the language that people are speaking, I'm not talking about the words that are coming out of their mouth. I'm talking about the bigger picture of how is their communication, what category is it in? Are they thinking rationally, intelligently, strategically, or are they responding emotionally? And you need to understand that in the courtroom, because lawyers are going to always speak in the intelligence arena. It's the classic, and then Google this. Most people aren't old enough to know what I'm talking about, but Google Joe Friday from Dragnet back in the day when it was in black and white. And the actor playing Joe Friday, his famous line was always, when he was interviewing witnesses, he always said this: "Just the facts, ma'am." So he was always talking about intelligence. He did not want to know about the emotional impact of this event. All he wanted was the facts, because here's the law. Robbery is, and then here's the definition. I need the facts that meets this definition so I can prove my case. So that's how lawyers are talking. Intellectual language, the elements of the crime, the facts of the case. That's not the language the jury is talking, at least not to begin with. Jurors come to court, and unless they've been on a jury before, they are walking in completely blind to what's going to happen. They know nothing about the system. So they're in an emotional state. They could be anxious. They could be mad that they had to take off work or cancel plans, or something that it's ruined their day, and this trial is going to last 3 or 5 days, and they are pushing back, and they just want it to be over. Some of them may be want to be CSI, detectives and all that kind of stuff, and so they're anxious to hear all the facts and to analyze it and come up with their own opinion of how they would have done it differently, because on CSI, this is what they did, and all sorts of stuff. So they come in this emotional state of anticipation, and how could they solve this case before all the testimony is over? So here's the thing, the principle you need to understand is that information can only effectively be received and processed with an emotional person once you've satisfied their emotional needs. Now, one of their big emotional needs is they firmly believe somebody's going to lie to us. So they're really keyed up on how can I tell who's lying and who's telling the truth. So those are the 4 main principles of when you go into the courtroom. And it's not unlike when you're interviewing witnesses or even a suspect, that you're processing a lot of this, it from that side of police work. And you were taught, establish rapport with a suspect before you start asking questions about the actual crime, all those things. But the flip side too is that sometimes we go into calls for service, like a domestic violence or a family trouble, and everybody's all hyped up. It's very emotional, and we have the training and the officer safety is at the front of our mind, and we start barking out orders. We start barking out information. You sit down. You come with me, and we don't acknowledge the emotional trauma that people are going through at this time. And if we do acknowledge it and we speak the emotional language, then we're calming them down to the point where we can now talk the intellectual language. So simple things, and you do it all the time. Honey, I really understand you're upset. Is there anything I can get you? Would you like a glass of water? I know this has got to be very traumatic for you to find out that your son has been shot. And who can I call to help you? and you start addressing those emotional needs. The same principle applies in the courtroom, that you need to address the jury's emotional needs before you jump into the intellectual language and conversation about the facts of your case. So here's how to break that ice. Every single case you testify in, there's two things that you have to articulate. It's got to come out of your mouth. It cannot be assumed or presumed by the court. And as a matter of law, it's literally somebody's got to say, this happened in, and like I'll give you just the example because I was a cop in Dayton, Ohio for so long, or when I was doing human trafficking investigations for Colorado Springs PD. In Dayton, this occurred in the city of Dayton, Montgomery County, state of Ohio. Venue and jurisdiction. You have to establish those verbally on the record. First case I ever tried, and I thought my shit didn't stink. I was on the national mock trial team at the law school, and all that kind of stuff. And I got hired to be a prosecutor before I even got my bar results. So man, my ego was up there. So my first day on the job, September 29th, 1982, I was the assistant city attorney and prosecutor for Huber Heights, Ohio, small community just outside of Dayton. And it was night court, 6 to 9 p.m. And I go in, and the clerk gives me this big stack of cases, and it's like all traffic. And there wasn't even any criminal cases on that night. And I put the first cop on the stand. It was a radar case, speeding case. And I asked the officer, tell the judge what happened. And he goes through the tuning forks and does all his stuff and tells his story. And all I did was, what happened next? What happened next? I had I just let him tell the story. And when I was done, the defense attorney, because this person was going to have points on their license, so they hired a defense attorney. Judge Pat Foley says to this defense attorney, any cross-examination? And the attorney goes, no. And I'm like, yeah, that's right, because I did a good job. And then judge turns to me and goes, Mr. Walsh, you have any additional witnesses? No, Your Honor. State rest. Defense, do you have any witnesses? No, Your Honor. They don't. And a Rule 29 motion to dismiss. Judge goes, granted. And I'm like, what the hell just happened? And so the judge calls me to a sidebar, and he goes, Pat, you didn't establish venue and jurisdiction. You did not ask if this happened in the city of Huber Heights, Montgomery County, state of Ohio. And the Irish in me, because I'm 100% Irish, born in Ireland, so I'm just like stubborn as all get out. And the judge was Irish, Pat Foley. So the Irish in me wanted to go, well, Judge, where the hell else would it have been? That's a Huber Heights cops that was on the stand, and we're in Huber Heights. But I didn't say that. I just thanked him and said, yes, sir. So I call my next case. It's a speeding case. Go through everything, and at the end, I asked the officer, did this occur in the city of Huber Heights, Montgomery County, state of Ohio? He goes, yes, sir, it did. Nothing further. No cross-examination was done. And the defense attorney on that case stands up and says, no witnesses, Your Honor, Rule 29, motion to dismiss. Judge Foley goes, granted. And I'm like, what the hell just happened here? I asked venue and jurisdiction. So he calls me sidebar, and he goes, Pat, you didn't ask if the speed limit sign was duly erected and unobstructed. And at that point, I said, Your Honor, that's not in the statute. He goes, it's a rule of court. So I didn't know the rules in his courtroom. I learned them pretty quick, and I never lost another case based on a stupid traffic speed limit sign being duly erected and unobstructed, or venue and jurisdiction. So we need to know the facts of our case, but we also need to know the rules of evidence, rules of criminal procedure. So if you know you're going to have to establish venue and jurisdiction, and we always do it, is, well, I was dispatched to 335 West 3rd Street, City of Dayton, Montgomery County, State of Ohio. And we do it just because we have to. It's one of the boxes we got to check off. But here's the opportunity we are missing to meet that emotional language that the jury is speaking, because they are anxious. They are confused. They want to know that somebody's not lying to them. You do it with venue and jurisdiction. You don't just simply say the address that you were dispatched to, and that's in the city or county of whatever, and state of Ohio, whatever. Every single community has a landmark. Every county in every state has a landmark. In Dayton, Ohio, there was actually a couple. The University of Dayton, the arena, basketball arena, and that's where the play-ins for the NCAA March Madness. That's the first games are played right there. And then the other one was actually the Dayton Dragons, single A baseball stadium. Holds the Guinness Book of World Records for the most consecutive sellouts by a professional sports team. What you do when you say I was dispatched to, and you give the address, and you're looking at the jury, and you're going to turn that video on in their mind, and you're going to prove to them you're not a liar. You look at them and go, 335 West 3rd Street, City of Dayton, Montgomery County, Ohio. You might recognize that location is just a few blocks west of Dayton Dragons baseball stadium, and you nod your head. And if people on the jury nod their head in agreement, they just have told you. You're having a conversation with them, even though you're the only one talking. You're having this conversation, and what you have just told them is, you told me the truth, because I can picture that. They picture the stadium. And you're right, 335 West 3rd Street is west of that, downtown Dayton. The other thing, because now you've told them something that they know to be true, psychologically now you have changed the language, because they like you and they trust you and they appreciate you for telling them something they already know to be true. And now you can start talking the intellectual language of the facts, the elements of the crime. Look at it like this. Let's say you have the disorderly conduct, resisting arrest, and assault on a police officer. And you get that agreement from the jurors, the ones that nodded their head when you told them where this was. It's in close proximity to something that they know to be true, that landmark, whatever it is. Then you get to the facts of the case. Now we're talking intellectual language. I told the defendant to stop his yelling and screaming and throwing stuff in the street. And I nod my head when I say that. I'm looking at the jury. I told him, I'd nod my head, not bobblehead, but a little nod of the head. I told him, stop what you're doing. And he didn't. And then I nod my head like in a negative way. And the jurors are watching me. And what are they watching? My nonverbal communication. They're hearing what I'm saying, but my nonverbal communication is reinforcing what I'm saying. I have that eye contact. I'm using the head nod. I'm getting their agreement, and they are communicating back with me. Jurors will nod their head in agreement, and they're listening to you and they believe you. And that's a great icebreaker of telling the truth, so that when I get to the facts of the case and I nod my head, I told him to stop and he didn't. And then I told him he was under arrest, put your hands behind your back, and he didn't do it. And he put up his fist like this. And now you're doing the nonverbal. You're demonstrating. They can visualize, because the defendant's sitting right there. They can picture him putting his fist up in a boxer stance. And the fight, I reached out and the fight was on, and he hit me right here in the temple, and it hurt. Because what's assault? Cause or attempt to cause physical harm. He hit me right here in the noggin, and it hurt. And I nod my head. I have just established the facts and circumstances that would lead a reasonable person to believe he committed assault. And in the courtroom, it's beyond a reasonable doubt. This is fun because defense attorneys don't expect you to do it because you have always been monotone, just yes and no, answering questions, and you don't want to be there. And guess who you're always looking at when you're being examined by the DA or cross-examined by the defense attorney? You're looking at the lawyer. You're not looking at the jury because you weren't taught that and get that and have that muscle memory like you do in street survival. So it's a lot of fun. So what we're doing is we're painting a vivid picture with words so that the jury is like right there in the middle of the event as you testify. Your nonverbal communication is the most important skill you need in a courtroom because we were all taught as cops. I mean, we're taught as little kids. You learn how to lie to your parents and control your nonverbal communication. Each one of our kids had a different tell of when they were lying, but they had something nonverbal going on. And we could tell, okay, now they just lied to mom or dad. Well, jurors are on hyper alert for nonverbal communication because we're brought up in the Western culture. That's how we determine 60 to 70% of the time, maybe even higher. There's studies out there as high as 80% of the time. People judge your truthfulness not by what you say, but by your nonverbal communication, lack of eye contact, all those things that you use on the street when you're talking to witnesses and suspects, the jurors using on you when you're testifying. So be conscientious about your nonverbal communication and be intentional on being truthful in your nonverbal communication. So the last thing I'm going to tell you, be strategic before you ever go into the courtroom. Anticipate. What are you going to be asked? Have a theory of your case. The theory answers the question why. Why did the defendant do X, Y, or Z? And have that in your head that you already know that when you're asked this question, you have practice up here in your mind. This is going to be my answer as I turn and look at the jury. It's not any different than you get a priority call on a burglary in progress. And as you're en route to that call, you're running through your mind. When am I going to turn my overheads off? When am I going to turn my siren off? When am I going to go dark on the headlights? Am I going to approach from the front or the back? And you're talking on the radio to other crews and you're coordinating before you ever get there. Do the same thing before you ever go to court. And even you can have somebody practice with you if you wanted to be that jerk defense attorney and ask stupid questions and try to attack you personally or whatever. No, by the way, I forgot to mention this. One of the funnest things to see and to enjoy is if you do with the jury what I'm telling you on direct examination and you're establishing that likability, you're establishing that truthfulness, you're establishing that relationship with them because you spoke to their emotional language first and then went into the intellectual language second. When a defense attorney gets up and is a jerk and starts attacking you verbally, look at the jury and look at their nonverbal communication as they look at the defense attorney going, the hell you doing? He's a nice guy. Grandma in the back row is saying, I wish my granddaughter would bring home a nice young man like that. And that's fun. because it reinforces for you you're doing things right and you're winning. And that's why I love going to court. I actually testified in a trial, 2 defendants, it's a murder case in Atlanta, Georgia. And I did this with the judge in a motion to suppress, and which we won. And immediately after the motion to suppress, we're going to go straight into the jury trial. And there were 2 defendants and 2 defense attorneys. And there was 4 or 5 of us had gone down to testify. I was one of the first ones on the stand. I was a lieutenant at the time. And when we won the motion to suppress, the 2 defense attorneys went over to the DA and said, "Tell Lieutenant Welsh to quit doing that crap." And the DA looks at him and goes, "What crap are you talking about?" And they said to him, looking at the judge and nodding his head when he was testifying. Because they knew I was going to do it with the jury. And I did do it with the jury. And the 4 or 5 of us we were supposed to be down there for 4 or 5 days testifying. We were done. Our part of it was done in under 2 days. On a murder case, I was asked 5 questions on cross-examination between the 2 attorneys. It works, and it's fun, and enjoy that opportunity to outsmart and be strategic and put defense attorneys in their place. Their clients, 99% of the time, are guilty as hell. And they're going to talk about everything but the evidence. So have some fun with it. Repetition's the mother of all learning. Have that theory of your case. Talk about the evidence. Reinforce it with the jury with your nonverbal communication. Now, I'm going to take this in a completely different arena, so maybe this will connect with you, that it all makes sense. Who are the great comedians that you like? Me, I like Jeff Dunham. Why is he great? Because he does all these things. He connects with the audience. He connects with them emotionally. He takes them on a roller coaster ride of laughter, and he gets a response. Commencement speakers. Who are the greatest commencement speakers? They know these principles, and they utilize them. And they know emotional language, and they know intellectual language, and they know how to use it and when to use it. They have a message. They have a theory to their speech, if you will. Or a pastor giving a sermon at church and is trying to educate and transform the lives of the parishioners, the listeners, to have them come to a conclusion that squares away with Scripture. Look at the State of the Union. Probably the State of the Union is one of the most glaring examples, if you will, of this emotional and intellectual language. And none of these are speeches. They're all conversations with the audience, with the listener. And there's feedback to the speaker, whether it's clapping, whether it's laughter, whether it's a groan, whatever. State of the Union, they get the little paddles that they're flipping back and forth. All those kinds of things. It's a nonverbal communication. In many respects, the laughter is verbal, but it's still only one person is actually doing the talking the whole time. So conduct your testimony in the same way. You're the only person talking, but make it a conversation and not a speech. So, love you all. Appreciate you being here. Catch all our episodes, past episodes. If you missed any, they're all online on your favorite platforms. Give us a review. Reviews help grow our community. We're pushing 1,000 downloads in 10 and a half weeks, which is awesome. Our newsletter is doing really well. We're pushing 800 subscribers to the newsletter on my LinkedIn page. So Pat Welsh, JD for LinkedIn, Warrior Servant Leader podcast is on all your favorite platforms. Join us, give us reviews, give me comments, and love you all. And see you next Tuesday with a new Taco Tuesday.